So when the Sustainable Path Foundation folks were putting this event together, I remember asking Erica how long we had to do the presentations. She said 20 minutes, and I said, well, what can a lawyer say in 20 minutes? So it's impossible. So just to start out with tonight, I think I'm going to pile on to Kate's list of how bad things are, at least from the beginning of her presentation. Things are pretty bad, and they're getting worse. I'm going to read off a list of statistics that we actually presented in Mount Vernon at the Martin Luther King Jr. Day commemoration event. So here's some statistics. In the United States, 570 billion pounds of municipal waste is produced, with 60% of that waste ending up in landfills or incinerators. That's each year. 570 billion pounds of municipal waste. 4 billion pounds of toxic chemicals, including 72 million pounds of known carcinogens, are released into the atmosphere from 20,000 different industrial polluters across the United States. 2 trillion pounds of livestock waste, laced with antibiotics, hormones, and chemicals, are dumped into waterways and applied to land on an annual basis. 11 million people live within 1 mile of a federal Superfund site in this country. The use of fossil fuels for 85% of our energy use impacts the health of 6 million people in the United States, while of course warming and polluting the atmosphere and the planet. 80,000 industrial chemicals currently are in use in the United States, with more than 700 now found within each human body. And Kate made reference to this, the toxic trespass. 1,800 new chemicals are introduced annually. 1,800 new ones annually. 40% of our waterways in the United States fail to meet even the minimal requirements of federal and state clean water laws. 1/5 of all animal and plant species cling to the edge of extinction. Fisheries are collapsing, and deforestation has resulted in the removal of more than 90% of America's forests, America's original forests. It's pretty bleak out there, and the situation's worsening rapidly. So what do we do with these problems? What do we do with these massive problems that we wake up every morning, we read about in the newspaper every morning? Well, we write letters to Congress, urging them to do something. We hold protest marches, we buy Priuses, we invest in green stocks, we buy local, we bring our own bags to the grocery store, we change our light bulbs. We write letters to corporate CEOs begging them to do the right thing. As Derek Jensen, author, a friend of mine, I think was one of the best writers of our generation in terms of being a heretic about how existing systems are set up. He says that taking those actions, which we're taught of as allowable activism, taught that we can do certain things as activists but can't do others, he compares that type of activism as a response to these huge monumental environmental problems we face. He says it's like the French resistance fighters vowing to compost to stop Hitler. He goes further in a piece called Beyond Hope, which some of you may have read. He's a columnist for Orion magazine. And I have to read this quote because it's my favorite one from Derek. He says, on our activism in general and how we actually work to try to solve these big problems. He says, quote, "Does anyone really believe that Weyerhaeuser is going to stop deforesting because we ask nicely? Does anyone really believe that Monsanto will stop Monsantoing because we ask nicely? If only we get a Democrat in the White House, things will be okay. If only we pass this or that piece of legislation, things will be okay. Nonsense. Things will not be okay. They are already not okay, and they're getting worse rapidly." Right? The problem is, even when we do confrontational activism in this country, when we move beyond the bringing our own bags to the grocery store and changing light bulbs and writing letters to corporate CEOs begging them to change their practices, or writing letters to Congress begging them to do something that we know needs to be done, even when we move outside of that framework, we move into a regulatory framework, which is, for example, when a toxic waste incinerator is siting in a specific town or a specific municipality. Groups organize around the kitchen table. I think it's the only place that democracy happens anymore today, is around kitchen tables in communities that are facing these types of problems. And immediately what happens is they usually find a lawyer, and that lawyer tells them, well, what you need to do is appeal the permit that the state has issued to put this toxic waste incinerator in or this other project in. And so we begin fundraising for the lawyers in the communities. We begin fundraising to pay the lawyers to do the permit appeals under regulatory structures that the corporations wrote to actually ostensibly regulate themselves in the community when the communities rise up to try to challenge them. We wonder why after 40 years after the major environmental laws have been adopted in the United States, why things are worse today by almost every major environmental statistic than they were 40 years ago. And the answer is very complicated, but part of it is that our work isn't working. Our work is not working. The solutions and activism that we use are not commensurate with the problems that we face. And so the Legal Defense Fund, the Community Environmental Legal Defense Fund, which we founded in 1995 to do something quite simple, which was to provide free legal services to community-based environmental organizations. For 8 years, we spent time in the trenches doing these permit appeals that the state would issue. The state would issue a permit to a corporation to put a particular facility in. We would ride to the rescue on top of the white horse to the community group and say, we can help you. Never trust anybody that says we can help you. And the community group would say, well, please help us. And we would say, we'll help you. We'll come in. We'll appeal this permit that was written, issued by the state agency and under which the corporation is operating. And we would go into court and we would argue to the judge that the permit application that was submitted by the corporation was missing something. That's in essence what conventional environmental law is today, is that something's missing from the corporate permit application because they haven't dotted all their I's or crossed all their T's as they go through the regulatory process. We would find something missing. We would argue to the judge, Your Honor, under little 3, little c, little d, little Roman numeral 2, little I, little e, little 2, little c, that there wasn't a large enough bond posted for the road that's going into the toxic waste incinerator. And therefore, the permit was issued wrongly, and now you need to repeal it and get rid of it and not have a toxic waste incinerator there. And what would happen next, of course, was that the corporate lawyers would come up to us, sometimes openly after we appeared in court to actually strike the permit down, and they would say to us, thank you very much. Thank you very much for identifying the deficiencies and the gaps and the omissions in the permit application that we submitted originally to get this permit to issue from the state. Thank you very much. You've identified the bond that's missing. You identified the signature that's not there. You identified the macroinvertebrate water study that needed to be updated. And guess what? 30 days later, they would come back with a new permit application. And the community group would come to us and they'd say, Mr. Linzey, we need you to do that jujitsu again that you did with the judge the first time around to get this permit thrown out, because now we're faced with a toxic waste incinerator coming into the middle of our community. And we would say to them, we'd like to help. We're really sorry, but there's nothing for us to use anymore within the regulatory system because the corporation has now dotted all the I's and crossed all the T's. And eventually, 60 days, 90 days, 100 days later, what that community would get was a toxic waste incinerator in the middle of their community. Funny part about all that process that we did for 7 or 8 years as a traditional environmental law firm, the funny thing was we had a great win-loss record. You know, it was 100-3, 100 wins in front of administrative law judges and 3 losses. What was fascinating to me was that the liberal progressive community in the United States, they didn't give a shit that the toxic waste incinerator that we had been fighting eventually went into the community, or the 10,000 head hog factory farm eventually went into the community, or wells were being sucked dry by Nestle Corporation coming into communities to take water from those communities. What the liberal progressive community cared about most was the win-loss record that we had on paper as an environmental law firm. So during that period, we got invited to the White House as one of the top 10 environmental law firms in the country. We got the awards, we got the funding, we got the recognition. But none of it was real. Because if you actually set foot in the communities that we were representing to fight these projects off, you would find nothing that looked like what our record did on paper, because eventually the corporations win. And that's the nasty little secret about how the regulatory process is set up, but they win. And so we came, as the Legal Defense Fund, to a point where we almost shut down our office back in the late 1990s. We said to ourselves, we were created to actually protect the natural environment. What we were doing was helping corporations build better permit applications. That's what our law firm was doing. And when we looked out at the landscape at other environmental law firms, guess what? They were doing the same thing. And guess what? That's what they do today. That's what conventional, traditional environmental law is today. And we wonder why we're losing. We wonder why we look out the window and see what we see, right? We wonder why ice floes are breaking off in the Arctic, right? We wonder that. We shouldn't wonder anymore. It's because our activism is so flaccid. It's non-existent because it's been scripted for us. The corporate boys, when they write the regulatory plans, when they write the regulatory regimes, they write them. And for us to think that it devolves any decision-making power on us whatsoever to actually decide what our sustainable community is going to look like, we're on the tip of insanity because we keep doing the same thing over and over again without getting a different result, which is the definition of insanity. So what happens next in this little world of ours? Well, we can continue doing the conventional traditional activism, and we will watch and continue to see the things that we love be destroyed, right? Or we can do something different. The great thing to me, I wake up in the morning wondering why anything's happening at all, right? I'm amazed that anything's actually happening at all because we've been so beaten down. The law is not ours. The constitutional structure is not ours. Corporations have constitutional rights that allow them to have more rights than the communities in which we operate. How did that happen? Well, we've had about 100 years of this stuff happening. People get upset about the Citizens United decision dealing with First Amendment election spending. Well, guess what? It's nothing new. It's nothing new. It's been here for 100 years. So what are people doing in communities when they come up against the toxic waste incinerator? Well, it used to be they were doing the same thing that people were doing for the last 50 years, which is diving into the environmental regulatory process and nothing happening. That changed back in 2000. I don't know why it changed. I still don't know why it changed. We basically follow stuff that happens and then help it get bigger. That's what we do. In the year 2000, a small community called Wells Township in south central Pennsylvania, right up against the Maryland line, population 529, right? Conservative, Republican, not liberal, not progressive, were hit with a series of factory farms coming into their municipality. Factory farms, for folks that don't know what these things are, in Pennsylvania, 10,000, 15,000 hogs jammed into a confinement operation, essentially part of what we call this corporatization of agriculture in the United States. Believe it or not, 4 corporations now control over 70% of pork production in the United States. One company, Kraft, controls over 60% of cheese production in the United States, and 3 corporations control 60% of chicken production in the United States. The way they do that, the production now, and we're in a sprint mode here because I don't want to get the hook over here from, but the way they do production now is essentially we've had hundreds of thousands, if not millions, of decentralized family farmers who have been replaced by a handful of agribusiness corporations in this corporatization of agriculture scheme that's emerged. The farmers who now grow for the corporations don't even own their own animals. So a farmer under contract to a mega corporation to raise animals, the title for the animals is held by the agribusiness corporation. Unless, of course, an animal dies, and then title to the dead animal passes to the farmer for disposal. In addition to that, the large corporations control everything from feeding schedules to vaccination schedules, and essentially control this closed market now, where farmers have become serfs, in essence, to those mega agribusiness corporations. Suicide rates for farmers, suicide among farmers is now the #1 cause of death for farmers in the United States, surpassing equipment-related deaths as non-natural type of death in the United States. And the reason for that is because a family farm culture is becoming extinct. And so folks who have run a family farm for 6, 7, 10, 15 generations are now losing them to this corporatization of agriculture that's occurring in the marketplace. What happened in Wells Township, population 549? They were faced with a couple large factory farm operations coming in from some of these large mega agribusiness corporations. The environmental lawyers who they went to get help from, which included some of my friends, said to them, well, we're sorry, you can't ban factory farms from coming into your community. Can't ban factory farms. Why can't you ban factory farms? Well, guess what? You can't ban anything. So whether you ask the corporate lawyers and the environmental lawyers, they'll tell you the same thing, which is you have to allow all legal uses within your municipality. It's black letter law in the United States. It may sound strange when you first hear it because people say, well, we have zoning. We can keep things out from zoning. Well, no, you actually have to allow all legal uses into your municipality. You have to put them someplace and you can't prohibit them outright. So if the city of Seattle said, gee, we don't think big box stores are a really good idea for the city of Seattle, and you pass a 1-paragraph ordinance that says no big box stores within the city of Seattle, the first thing that happens is a lawsuit from Costco or from Walmart who says, you've violated our corporate constitutional rights because we have a constitutionally vested interest in being allowed to carry out a legal use within your municipality. What constitutes a legal use? It's anything that's permitted or regulated by the state. Low-level radioactive waste sites, legal use. Corporate pork production, legal use. Waste, commerce, legal use coming into the states from out of states, out-of-state garbage, out-of-state waste. You name it, it's defined as a legal use. Communities are prohibited from banning the legal use. If you act to ban it, what happens next is you get a lawsuit from the corporation to overturn it, but in addition to that, damages in the form of future lost profits, which the municipality can be sued for by the corporation as a result of violating the corporate constitutional rights of that company. So, little town of Wells Township, they say, go to the environmental lawyers, the experts, and they say, what can we do? And the environmental lawyers say, well, you can appeal the permits. And the Wells Township supervisors say, well, wait a minute, if we appeal the permits, that means all we can talk about is manure, because that's all the permits are about. It's how much liquid manure can be spread per acre of land. And they said, that's going to allow it in. And the environmental lawyers said, that's right, because regulating means allowing it in. The verb regulate means to allow it in so you can control the flow of it. That's what regulating means. And the folks in Wells Township said, well, that's bullshit. They said it a number of times, including my presence when I got called in. They said, well, that's bullshit. We have, we govern our own community here. We have a democracy in the United States. And God damn it, we're going to exercise that democracy here in Wells Township. And we said, fine, what are you going to do? And they said, we're going to ban corporate farming within this municipality. We're going to ban the ability of these agribusiness corporations to actually farm, to engage in farming, and to have these output contracts, these farming contracts within our municipality. And we told them, well, you can do that, but the structure of law that's set up in the United States means that the hammer comes down on you when you attempt to actually prohibit something in the interests of building sustainability within that community. And what comes down on you is a series of different legal doctrines that have been manufactured over the past 120 years to protect certain property interests over democracy interests in a municipality. In essence, those doctrines create a system in which corporations have more rights than the community majority in which they're doing business. That always sounds strange to say, but that's the situation that we have in the United States today. The Wells Township supervisors fired their environmental lawyers. They said, we have no interest in going through the regulatory system because we have no interest in allowing these folks to come in. And some of the supervisors were also farmers. They understood this true big frame of the problem about this corporatization of ag. They then hired us. And we were at a point where we thought it was bullshit too, that municipalities weren't able to do this and that there was a system of law that kept them in that box. And so we assisted them to draft the first in Pennsylvania municipal ordinance that banned corporations from farming within the municipality, right? Banned corporate factory farming in the municipality. Funny things started to happen. When I had private conversations with these Wells Township folks, I said, well, you know why you can't do it? And they said, sure, but if we do it, maybe someone else will do it too. And then maybe someone else will do it in addition to them. And then maybe someone else, and then maybe it'll spread over here and spread over here. And sure as shit, that's what happened. It went from Wells Township all the way into the rest of Fulton County, so several municipalities there, then up to north central Pennsylvania, out to western Pennsylvania, and out to eastern Pennsylvania. It's fascinating to watch. Basically, people acting unconstitutionally and illegally in the open, right? Directly confronting an illegitimate system of law, which is something that our activism has steered clear of because it's afraid to do it. It's afraid to confront those structural constraints directly. In addition to the corporate factory farm issue in Pennsylvania, something else started to happen. And this dealt with sewage sludge. It's good thing it's after dinner and not before. For anybody who doesn't know what sewage sludge is, it's everything that goes down the toilet or down the drain in an area that's hooked up to a centralized sewage treatment system. We used to take the sludge and dump it off the coast of New Jersey. Some people who have been in that area of New Jersey probably think that's a good idea to dump it off the coast. What happened was it created a dead zone off the coast of New Jersey, killing all the life, because guess what? When you dump the stuff into the ocean, that's what it does. The brain surgeons that gave us ocean dumping of sludge came up with something called land-applied sewage sludge. And then they legalized it through a federal regulatory system administered by the EPA. Today, 60% of all sludge, that's the stuff coming out of the toilets and the hospitals and some therapeutic waste and all kinds of stuff, actually goes into the waste stream and is applied to farmland where we grow our food, not just for human consumption, but also for livestock consumption. Pennsylvania, some people were upset about sewage sludge being put on land next to their houses, because guess what? Philadelphia sewage sludge doesn't get put on land near the multi-million McMansions right outside of Philadelphia. It's actually shipped into the rural part of PA, where a lot of stuff gets dumped because it's rural, not populated, and very little political power in the legislature to stop it for those communities. Those communities came to us and said, well, we need help too. We've seen what you're doing with the factory farm stuff and keeping corporate farms out. We want to keep corporations from sludging us. And it turns out 4 corporations control 60% of the sludge market in the United States as well. And so these communities came to us to get us to draft an ordinance. We drafted an anti-corporate sludging ordinance, which was then passed not by 5 or 10 or 20, but by 80 municipalities in Pennsylvania. We have about 1,200 rural municipalities, just to give you an idea. And keeping in mind, these were being combined now with the factory farm ordinances. About 100 different communities across the state of Pennsylvania had started to put up their middle finger to the factory farm corporations and to the sludge corporations and to the legislature for enabling those corporations to do what they do within those communities. What happened next was the state intervening. The state legislature stepped in and drafted a bill called ACRE. And what did ACRE do? ACRE authorized the state attorney general's office to sue the municipal governments to overturn the ordinances that they were passing to keep the sludge and factory farm corporations out. Now, some of you might think, if we live in a democracy, wouldn't it be wonderful if the state actually intervened on the side of the communities once in a while, rather than intervening on the side of the corporations that were attempting to use the communities for what they want to do. At about this time, one of our communities also got sued by an agribusiness corporation who came in saying that your anti-corporate farming law violates our corporation's right under the Constitution, so corporate constitutional rights. In the United States today, corporations have the same rights as you or I. Walmart has First Amendment rights, Fourth Amendment rights against unreasonable search and seizure, Fifth Amendment due process rights, 14th Amendment equal protection and due process rights. They have the same Bill of Rights protections as you as a result of rulings back in the 1840s and the 1860s and the 1880s giving corporations Bill of Rights protections from the U.S. Constitution. Okay? So, in Pennsylvania, with this lawsuit that was filed, the corporation said, number one, you violated our corporate rights and you owe us damages, right? We're going to sue you for damages. Number two, you violated Dillon's rule. Dillon's rule is this concept that municipal governments are in a relationship of a parent-child to the state. That the state government is the parent, the municipality is the child, and the child can't do anything unless explicitly authorized by the state. The argument being that banning corporate factory farms and corporate sludging was not a power given to the municipality by the state legislature, and therefore under Dillon's rule that the ordinance needed to be overturned. And finally, there's the third horseman of the 3 horsemen, which is preemption, which is corporations routinely use our state legislatures to outright preempt municipalities from passing stricter environmental standards than the state has passed. What was fascinating about that lawsuit, because it was framed differently, it wasn't a community trying to regulate manure from a factory farm facility. It was a community saying no to corporate factory farms right off the bat, a prohibition. That other communities who thought that we live in a democracy as well began actually watching the legal system and the legislature dominating these municipalities who were standing up for their right to local self-government to say, we don't want this kind of unsustainable agriculture within our community. And fascinating enough, at the same time that folks were starting to explore this corporate rights, community rights, the need for structural change stuff, they started talking about something called rights of nature. This concept that under our system of law, nature is property. Ecosystems are property. If you own a 10-acre piece of land within the United States, it carries with it the right to destroy the ecosystems on that piece of property. That's the environmental protection system that we have today. It's led a lot of people to say that we've never had an environmental movement in the United States, because the environmental movement that we have has been based on a property ownership type of concept and structure for environmental protection, not on a rights-based structure of environmental protection. And so coming out of these rural Republican conservative communities, they began writing ordinances creating ecosystem rights. There are 36 of them now in the United States, Maine, New Hampshire, Virginia, and Pennsylvania, in which the communities have declared that nature is not property within those municipalities, that ecosystems have legally enforceable rights within the municipality, that the residents themselves can defend and enforce. And those 36 communities in the United States eventually bled over into the country of Ecuador, where we were invited down to talk about rights of nature. They actually became the first country to write rights of ecosystems into their national constitution, which was ratified in 2008, becoming the first country to switch from a property-based environmental protection system to a rights-based protection system. So where does all this leave us? Well, there's a lot of stuff that's been done in Pennsylvania. It's a revolt. I mean, what's happening in Pennsylvania right now is a full-scale revolt. It's almost collective nonviolent civil disobedience, where folks are not just moving forward individually to lay in front of the bulldozers and then the full force of the criminal state comes down to arrest them and throw them into jail. It's that communities are beginning to seize their municipal governments, to turn them up against the state and federal government, to in essence build legal structures for sustainability. It sounds really strange to me to say this, and first time I heard of it, it made my brain go a little wacky too, but the current situation of the law in the United States is that sustainability is illegal. Sustainability is illegal because sustainability itself is prevented from being attained by a structure of legal rights that protects property and commerce over the rights of communities, nature, and people. That's in essence the constitutional structure that we have. What I think we're seeing in the United States today, because this work is spread out to Maine and New Hampshire, it's spread out to Spokane, it's beginning to take sprout here in Seattle, is that we're looking at a new civil rights movement. And it's one that redefines community. It's not just the people in the community, but also the ecosystems and nature itself within those communities. It has resulted in about 140 new ordinances. And we think that those ordinances that have been passed in these communities as legally binding ordinances are essentially the blueprints for new constitutional structures in the United States. That what we're seeing is a constitutional rights movement. Just last year, communities in Pennsylvania joined together to talk about a state constitutional convention, to begin changing the state constitution to parallel and align what's happening in these local communities. What's arising in these communities now as a next evolution of this work are these Bill of Rights, that communities are beginning to pass local bills of rights that have the effect of banning and prohibiting those activities which would violate the Bill of Rights within those communities. And part of that is actually limiting rights for corporations. We have about 50 communities now that have stripped corporations of constitutional protections within their municipalities. And it's all part of a learning and evolution process to say to ourselves that our activism is stunted because we assume that those legal doctrines are going to be around forever, and we work around them. It's what prior people's movements didn't do. Separate but equal was a legal doctrine. People didn't work around it, they took aim frontally at it. The abolitionists, African Americans, were property at one point. Killing a slave was a property crime. Damages were paid to the slave owner. The slave had no rights under the system of law. With suffragists, rape was a property crime. It was damages paid to the husband. There were no rights that are accrued to the woman. A rights-based activism means actually driving ecosystems and nature and our communities, which are currently treated as property of the state, into being rights-bearing entities. I have to say that I don't see a shortcut to that. It's a long march, but it's starting to happen. In November of last year, the city of Pittsburgh became the first major municipality to strip natural gas corporations of constitutional rights within their municipality, to ban natural gas fracking, and to recognize that ecosystems within the city of Pittsburgh were not property anymore, that they were rights bearing within the city of Pittsburgh. And now they're playing around with a test case to protect the Monongahela River from fracking chemicals that are being injected upstream, which actually damage the river when it runs through the city of Pittsburgh. I think what we're seeing again are the beginnings of a community constitutional revolt, and it's beginning to take hold in Washington State. Just to finish out with two quick things. One is Spokane, where in 2008, a community coalition of 24 groups, labor unions, environmental organizations, and community groups came together to begin drafting a new community Bill of Rights for the city of Spokane. Those 24 groups eventually qualified it for the ballot. It went on the ballot in 2009. It lost big. It had a bunch of things in it, everything from healthcare to housing to environmental protection to corporate rights, all that kind of stuff. The group then reformed and has now requalified a new ballot initiative for 2011, which contains 4 core rights. Number one, that neighborhoods have the right to deny zoning changes for development corporations that want to come into their neighborhoods. Number two, that the Spokane River and Spokane Aquifer have certain rights, legally enforceable ecosystem rights of their own. Third, that employees have constitutional rights in the workplace. Another nasty little fact in the United States is that when you cross the threshold into your private employer, you're automatically stripped of your constitutional rights, your Bill of Rights protections. And number four, that corporate rights, when they come into conflict with the Bill of Rights within the city of Spokane, will be subordinated to those community rights. And that's what the Community Bill of Rights campaign is this year in the city of Spokane. There's a nascent effort underway here in Seattle called Envision Seattle. A guy named Jeff Reifman, who organized some democracy schools in the city of Spokane, is pursuing putting together a community Bill of Rights perhaps for the city of Seattle. We've also drafted an ordinance that would be the first municipal ordinance in the United States to guarantee net neutrality within the city of Seattle. Right now the net neutrality stuff is being fought out at the federal level. It's diluted. It's not very effective. The question is, can we move this organizing into a municipal level and drive things like net neutrality forward? So, in doing the Martin Luther King Jr. Speech, I thought it would bring a smile to his face when we decided to actually call this work Collective Municipal Nonviolent Civil Disobedience. That our civil disobedience has to become collective, because if it doesn't, we're pretty screwed. And communities will get fried. And that's the legacy here, is to create a new civil rights movement that finishes the work that all these folks that came before us started. Thank you.